Mr. Bangamavo. Accused 2 and 14, Mr. Isaacs. I'm told that Mr. Kipido is standing in for Mr. Isaacs. Accused 5, 6, 7, and 10, Mr. Namanje. Accused 4, Mr. Kasper, who is absent. Mr. Namanje is standing in for him. Accused 9 and 15, Ms. Gebhardt, and we are ready to proceed.
Your Worship, maybe if we may wait a bit so that they can settle down.
Yes.
Please, I got Your Worship. Yes, Your Worship. I confirm my appearance for first, third accused persons. As I indicated last week, I'm no longer on record for accused number 8. Please, the court, Your Worship. I'm ready to proceed.
As the court pleases, Your Worship, I continue appearing for accused number 5, 6, and I'm representing, standing in for Mr. Casper on record. As the court pleases.
As the court pleases, Worship, I confirm that I appear for accused 2 and 14. As the court pleases.
May it please the court, Your Worship, I appear in these proceedings for accused person number 9.
We can proceed. Accused number 8. You still don't have your lawyer at court. Your lawyer is not at court.
Yes, Your Worship.
Just speak up.
Yes, Your Worship. I was told that they will be here today, but
We are proceeding. What is your attitude? Your lawyer, in the absence of your lawyer, what do you want to do, or the court to do?
I will observe Your Worship and wait if the lawyer will appear.
Do you have any, you know that from last week, Friday, questions were put to the 5th applicant under oath. Do you have any questions to her?
I don't have any question, Your Worship.
Then you can be seated. Advocate, we can proceed.
Thank you, Your Worship. Now, Mr. Hamukwaya, just to start, I just want you to inform the court, prior to your employment at Namcor, where were you employed, ma'am?
I was at the Bank of Namibia for 8 months, and prior to that, I was at Puma Energy for about...
Did you say Bank of Namibia?
Yes, Your Worship, for about 8 months. And prior to that, I was at Puma Energy.
Okay, at Puma Energy, what position did you occupy there?
Financial controller.
What does a financial controller do?
Again, just managing the finances of the company.
Which year was this? From what period to what period? Were you at Puma Energy as financial controller?
I think 2012.
Okay, and then at Bank of Namibia?
2015.
What position did you have at Bank of Namibia?
It was under banking supervision.
Okay, and these two positions,
You just said under banking supervision.
Yes, Your Worship, I can't recall the position right now.
okay, these two positions at were they all executive positions, or what were
No,
they?
the financial controller was middle management, and Bank of Namibia, it was more of a consultancy, on a consultancy basis. It wasn't a permanent position.
Okay, so then when you left Bank of Namibia, that's when you joined Namcor.
Correct.
And from the start, did you just have
No,
the...
I was a financial controller
Okay, at Namcor.
at Namcor, appointed in 2016. And for 2 years, I was a financial controller, but I also acted as the executive before I was appointed to executive position in 2018.
So it will be safe, or it will be yes, it will be safe to say your resume or your experience actually shows that you are experienced in financial management.
Yes.
Okay. Now, when you were at Namcor in the position of the executive for finance and administration, did you have people under you who were
Yes.
reporting to you?
Yes, I did. I had a team that was responsible for the trading company,
Okay.
as well as the team that was responsible for the exploration production company, the 2 subsidiaries.
Okay, and while at Namcor, you were part of the credit committee.
Yes,
And if I get it correct from the documentation that I've seen, you were actually the chairperson of the credit committee.
yes, that's correct.
And at the credit committee, some of the people that were there, is the commercial manager,
Yes.
Ms. Olivia Dunaiski. Is it correct?
Yes, correct.
And also Mr. Cedric Willemse, the manager for logistics.
No.
Or was he not there?
No, he was not.
Okay. There is a document which says
Sorry, the composition of the credit committee says.
Just wait, just wait.
yes. From the documentation, Your Worship, what I'm referring to, page 306 from Mr. Bangamavo's bundle.
That is exhibit.
Yes, exhibit E2.
Officer, can you assist me here? Mr. Pull for me E2 there. The last file there. What page?
306.
Three hundred and
306.
306. Yes.
Yes. At paragraph 6 there, are you there, Mr. Hamukwaya?
Yes,
Yes, it says composition of the credit committee. The first one, executive finance and administration, in
Yes.
brackets, chairperson, that is you.
yes, correct.
And then executive downstream and supply logistics, who was that?
That is Mr. Willemse.
Okay, so I was correct when I say it was him.
Yes,
Okay, and then I see there is also commercial manager there. That would have been Ms. Dunaiski.
yes.
Okay. And what was the purpose of the credit committee? What exactly did they do?
So if an application of a customer comes in to buy on credit, the application is submitted to the credit committee for the assessment of whether to approve or to recommend to the managing director.
Ma'am, just a minute. I have informed you from
Sorry,
the onset
sorry,
that
sorry,
you must breathe.
Sorry, sorry,
Yes,
Your Worship.
make your statement, pause. Both the court and councils are taking short.
Okay.
Yes. you can proceed.
So, Your Worship, the responsibilities are actually highlighted under Clause 5, but just to summarize, the Credit Committee is responsible for the review of credit applications of customers who wants to buy fuel on credit.
Okay, and then you would agree with me that on up there at paragraph 5, but specifically 5.5, it says Finance and Administration Department is responsible for providing monthly management reports on outstanding debtors and escalating problematic clients on a frequent basis, monthly to EXCO and quarterly to the ARCC.
Correct.
Okay, what is the ARCC?
Audit, Risk and Compliance Committee. It's a committee of the board.
Okay. Now, in terms of the credit committee, let's say you said you have to review credit application of clients who want to buy fuel on credit. Would there be instances where you have reviewed the application of a client and then you deny or you refuse them to be your credit customer, or what was
Yes, yes.
Okay.
There are criteria that we look at.
Okay. And then apart from Anacon, which is at the center of this whole case, there were other clients of Namcor who were buying fuel on credit.
Correct.
Okay. And then let's just proceed to page 310. It's still the same document, Your Worship. At paragraph 13, there is something that he says credit limit there.
Yes.
Okay. And just for completeness, yes, on page 302 there, I just want us to
302?
Yes, I was at 310, but I just want us to get the definition of credit limit first before I proceed.
Okay.
Yes, on 310 there are definitions there, but of interest...
310 or 302?
302, my apologies. Yes, there is a glossary of terms and definitions there, and of interest is credit limit. Are you there?
Yes.
And it says the maximum amount of credit that Namcor will extend to a customer with regard to purchase of a product.
Yes.
Okay. So now, before I proceeded to that, I was at page 310. And of interest to me is paragraph 13.3, which says every customer must be assigned a credit limit. You see that?
Yes.
Taking into account the following. Firstly, customer requirements based on anticipated volumes, including peak purchasing periods and prices and other trading terms. And secondly, risk category / credit worthiness. You see that?
Yes.
Okay, now, when you testified on Friday, you said there wasn't really a credit limit as such with regard to the clients, isn't it?
No, that's not what I said.
What did you say?
I said the credit limits, each customer is allocated a credit limit in the system.
So there was not a pegged customer credit limit. Is that what you are saying? Like a maximum set credit limit?
When a customer applies for credit and we approve that credit, say for example they apply 15 million.
Yes.
That 15 million is what is approved and is what is on the system.
Okay. Now, would you agree with me that on clause 13.3 there it says every customer must, and I want to emphasize the word must,
Yes,
be assigned a credit limit.
correct.
Yeah, okay. And in the present case, with regard to the fuel supply agreement between Anacon and Namcor, and I just want to take you to the exact page. Your Worship, the fuel supply agreement starts at 185, but the aspect of the credit limit is on page 191. And I'll read to you at 6.1. It says the quantity of the products, all products, ULP 95, Jet 1, lubricants, diesel all inclusive, purchased by the buyer and supplied by the seller under this agreement shall be 700,000 to 1 million liters per month, and in brackets, approved credit limit with a total approved credit limit of 15 million Namibian dollars.
Yes.
Okay. So, are you aware of the fact that Anacon also took over the debts of EcoFuel? That you are aware?
Yes.
And you are also aware that at the time that Anacon took over, in the session agreement, took over the affairs of EcoFuel, the amount that was owed by EcoFuel to Namcor was 73 million.
Yes.
Not necessarily an objection. My colleague said that Enercon took over the debt of ECO.
Yes.
And then in the last statement, he then put it to the witness that at the time Enercon took over the affairs.
Yeah.
He's wrong. There's no such evidence.
Concern?
Okay. Perhaps the word affairs is the one that has a problem there.
Yes.
Okay, but then the question is, when Anacon took over EcoFuel, there was a debt of 73 million that EcoFuel owed to Namcor.
Correct.
Yes. And then just before that takeover, Anacon also had its own debts of 35 million, you are aware?
Yes.
And this is despite the clause that I've read to you at 6.1 of saying the approved credit limit was 15 million. You are aware of that?
Yes.
Okay. Now, as a member of the credit committee, why did the debts of Anacon escalate to $15 million despite that from the fuel supply agreement that you had, the approved credit limit was $15 million? Why was that?
Okay. Correct. There is a $15 million credit limit.
Yes.
On Friday, I read clause 5.4 of the credit policy.
Just slow down, clause 5.4. Yes.
Yes. And I want to read it again so that I can put this into context. 5.4.
Yes, you can proceed.
5.4 says the Finance and Administration Department is responsible for maintaining the shortest possible collection period, which at this stage is 30 days after date of statement and for keeping bad debt losses to a minimum. The key word there is 30 days after statement. And I gave an example. If Anacon buys on the 1st of July, say product to the value of equal to their credit limit, 15 million, the books of Namcor closes only on the 30th of that month to reconcile the sale. Anacon is then issued a statement, say on the 1st. They only need to pay 30 days after issuance of that statement. Meaning, by the end of the month, their credit limit has already been exhausted in the system and in practice. But the amount is not yet due for payment. So the credit committee allows Anacon to again buy, knowing that the credit limit is exceeded. Same applies to all customers of Namcor. Husab, for example, has a credit limit of 100 million, but we only give them their statement on the 1st, meaning they need to still buy. So we allow them to buy because their amount is not yet due, and therefore they also fall outside the credit limit that was set in the system. This anomaly in the system was explained to the board when you correctly read clause 5.5, that we need to escalate problematic clients frequently to EXCO and to the audit committee. So it's not a secret that the system of Namcor allows customers to automatically exceed their credit limit. And that is why clause 5.9 also says the executive finance, the executive supply, and the managing director can determine credit limits. So it's not a secret, Your Worship, that these customers can exceed credit limit. Everybody at Namcor knows that the system is such. If it was Puma issues their invoices on they issue invoices on invoice. You are allowed to pay on invoice. Namcor, you are allowed to pay on statement 30 days after statement. Therefore, it was automatic for Anacon to exceed their credit limit. In fact, when we realized that Anacon was not paying around November, December 2022, we then put their account on hold. So we did not just stop there. We realized that they couldn't pay, or the money was not coming into the account of 520, and as a result, we put that account on hold. So yes, it's an anomaly in the system, and those that are charged with governance of Namcor knows this anomaly, Your Worship.
So, Ms. Hamukwaya, I just want to understand something. There is a clause in the fuel supply agreement that sets the credit limit, but yet you are saying there was an anomaly, as you call it, that they could exceed. What then was the purpose of the credit limit? If it's set there, but yet you still, Namcor still allowed Anacon to receive fuel way above their credit limit.
Yes.
What was the purpose then?
Correct.
Of having
That
such a
is
clause?
why, Your Worship, I read into the records clause number 8. Clause number 8
Of what document?
of the credit limit. It's on page 307. On Friday, I read that into the record. And I want to read again the second paragraph. Page 307.
Yes, proceed.
Credit limits are important and can be difficult to establish in a manner which is consistent with the potential risk inherent in an account. Financial information can provide important insight into the potential risk and the customer's ability to pay. A credit limit can be exceeded, but the credit committee looks at the customer's ability to pay. And that is why on Friday, I read out, with regards to Erongo, I read out the customer's payments on a monthly basis. Furthermore, the third paragraph, and I want to read the last sentence, which I also read on Friday. It says, in all circumstances, it is important to understand the liquidity. Liquidity means the ability of the customer's ability to pay, if they have cash, the solvency, whether they are able to settle their debt, and efficiency of the customer. So that is what we rely on, is the customer's ability to pay. And that, if it's demonstrated, we then give credit beyond what is set in the limit.
Okay, so I just want to understand something. So the credit limit in the fuel supply agreement and the clause in the credit policy, do you see that they do not speak to each other? Whereas one is saying this,
yes,
one totally disregards the other.
Correct, and that's why I said there is an anomaly, and that anomaly was explained to the board. They understood this.
Okay, so who drafted the credit policy of Namcor?
The credit policy was drafted in 2019, and it was approved by the board.
It was drafted by Namcor itself?
Yes, correct.
Okay. And who drafted the fuel supply agreement between Anacon and Namcor?
Legal department of Namcor.
Okay. And for me, kindly assist me. It looks like, from my reading, as you are trying to explain now, it will look like Anacon was almost like a favorite child of Namcor, and at some points, the policy says this, but Namcor itself goes against its own policies. Wouldn't you find that quite strange?
Yeah, I think the line of questioning or interrogating does not deal with the evidence on record, Your Worship. I think my colleague can pack that question and raise it during the closing submission, because if it is opinion that there are some discrepancies between the fuel supply agreement and the policy, the witness has nothing to do with that. Please, the court, Your Worship.
Counsel, any response?
Well, I think, Your Worship, that the documents actually speak for themselves. If the witness has an answer, I think she can answer. In as much as it says I can leave it for later, I think she can still be able to answer. Because I think I'm trying to put context here, whereas the credit policy says this, the fuel supply agreement says this. I'm saying, well, Namcor, it looked like Anacon was like a favorite child. Why was there an anomaly despite the two things not speaking to each other?
Yes, the court will allow the question. Any comment, if you have any?
Your Worship, Anacon was not treated as a favorite child. Namcor has many customers that buys on credit. They are all treated the same. I gave an example of Husab. Husab has a credit limit of 100 million. The statement is issued on the 1st. They are allowed still to buy even if they exceed their credit limit. That is the clause that I read under clause 5.4. There was no favoritism here. This is how the business was run for all customers buying on credit. And there are many, not just Anacon.
There is an aspect that you read. I just want to take you there. The one that talks about, of interest to me, is the one that says problematic clients. Do you recall that?
Yes.
Okay. I just want you to, in your own understanding, what would you understand by the term problematic clients as it appears there in the document?
The customer's inability to pay its credit account. A customer defaulting on payment. A customer perhaps being liquidated and is unable to pay. So those are the problematic clients.
Would you disagree with me if I say Anacon was one of those problematic clients that was not paying?
Anacon was paying, as we saw on the statement 520. It started defaulting, or they started defaulting in around, I think, November, December 2022. And one of the reasons that they provided to us was that they were not paid by their customer.
Are you aware that at the moment, then this is what the investigating officer will come and testify, that there is still a debt of 65 million that Anacon still owes Namcor, which has not been paid up to today as I'm speaking to you?
That, Your Worship, pertains to the debt that Anacon took over from Ecofuel.
And despite the fact that Anacon was a bad debtor, as we can see from the documentation and also from what you have said, Namcor still kept on supplying fuel.
That is not correct.
And I am putting it to you that you, as the chairperson of the credit committee, you should have exercised due diligence to ensure that no fuel continued to be supplied to Anacon when they didn't pay.
Can I answer? That is not correct, Your Worship. Anacon has 2 accounts, or I think 3 accounts at Namcor. The first one is all the debt that they took over. I took the court to the session agreement where there was an amount of 73 million. My charge there is a 70 million. The difference between the two is a payment from Anacon up until I think around December or so. So to say Anacon was a bad debt in as far as the debt they took over for the period under investigation, that statement is incorrect. They were paying. And statement 520 justifies that. Is evident to that. The second account, which is a fuel supply agreement, the one that you read, during the time of investigation, Anacon was paying. And I also read into the records referring to the statement 520. Anacon only started defaulting at the end of 2022. And when they defaulted, we put the account on hold. So I carried out my responsibilities as far as credit committees is concerned.
Okay, so as the executive with so much experience as we have had, and as chairperson of the credit committee, did you alert the board when you recognized or realized that there were anomalies in the payment? Did you alert the board and say, look, we have this customer, the credit limit is 15 million, let's cease or let's pause or let's stop supplying them fuel until they have paid? Did you alert the board?
You are 100% correct, I alerted them. Clause 5.5 of the credit policy states that escalate problematic clients on a frequent basis, monthly to EXCO and quarterly to the audit committee. Evidence is there where we submit a pack on debtors management to the trading board of Namcor Trading and Distribution and to the main board of Namcor Holding. On a quarterly basis, these documents were submitted. In addition to the debtors aging, the board also requested us to come up with a document called Debtors Recovery Plan. The debtors recovery plan is a document that stipulates all bad debts and what management has done, including EXCO, to make sure that the debtors are recovered. All those documents are in the hands of the board and also in each file of the customers. So to answer your question, on a quarterly basis, we submit to the board, and on a monthly basis, I present to EXCO.
Okay. It's correct that the fuel supply agreement was signed on 16 March 2022.
Correct.
And then I just want to understand, before I move away from that aspect, I want to understand when exactly did Namcor, upon realization that Anacon was a problematic client, when did that cease the fuel? You said you had escalated it to management, if I get you correct. But when was that? When then you stopped supplying fuel to them?
I can't specifically remember the date, Your Worship, but I remember that it was in late 2022. I think October, November day.
And will you be in a position to tell us at that time, in October 2022, as you were saying, what was the debt that was outstanding?
I think, I don't have the information with me, but I think about 35 million.
And is it correct that you are aware that the 53 million that was paid by Namcor to Anacon, from that 35 million was used to pay for that debt?
Yes, as per the asset purchase agreement and as per the fuel supply agreement clause 4.5.1, which was signed on, I think, the 22nd of March.
Okay. Now, let me just take you to just before I move away from that aspect. You heard me asking Mr. Mulunga specifically with regard to the findings of PwC. Are you aware of that?
Yes.
And one of their findings, if I can just tell you, Your Worship, it's on page 248 of Mr. Bangamavo's bundle. Yes. One of their findings, as we have already heard, is that there were unusual debtor accounts with significant outstanding balances, accounts that exceed credit limits, and accounts with unusual payment arrangements.
Yes.
So, you'd agree with me that from what I've just asked you now, when you look at the fuel supply agreement, which talks about credit limit of 15 million, but then the amount owed by Anacon to Namcor actually exceeded the credit limit. PwC was actually correct to say there were unusual debtor accounts.
Yes.
Okay.
Yes, we know there were unusual debtors accounts.
Okay.
And that is why we, on a monthly basis and quarterly basis, we present this information to the board.
Okay. Let's move on, Your Worship. Now at page 272 of Mr. Bangamavo's document. Now, yes.
Yes.
Now, you are aware of this document, and specifically it's the schedule of authority, but of interest is there on page 272.
Yes.
Which talks about procurement of goods and services, and in brackets it says as per board approved operational budget.
Yes.
Now, is it correct that at Namcor, specifically at the department that you were heading, each year you had a budget.
Correct.
And with regard to the present case, there was a budget for 2022-2023.
Yes.
And in order to buy assets, they should have been budgeted for.
Yes.
And in order to also buy assets, the ones that exceed 25 million should have been approved by the board.
Yes.
And in this regard, are you in a position to tell us whether the purchase of the bulk storage facilities, as we come to understand, were budgeted in the budget of 2022-2023?
Yes.
Okay.
Just
What?
hold on. Yes.
Are you saying the purchase of the bulk storage fuel facilities were budgeted for?
Yes.
Okay. Are you in a position to give us documentation to that effect to show that it was indeed budgeted for?
Okay. The initial request to buy assets came from the Department of Sales and Marketing. We have read Ms. Dunaiski's submission to buy these assets. In her submission, she stated that these assets have been budgeted for. So when I made the payment, I had that document and I relied on that document. So I then went to the budget, the approved budget, and I inspected the budget. There was an asset acquisition budget of 25 million, and there was a business development budget. Business development means that within the approved budget, the department, the requesting department, can at any point during the financial year acquire pumps, tanks, and canopy without going to the board. That's what business development is about. So, asset acquisition had a 25 million. Business development, it was indicated, had a 40 million. And therefore, as a result of that statement in that submission, and my confirming asset acquisition budget and business development budget, I then assured myself that the 53 million was budgeted for, and that is why I made the payment.
Okay, let's take it step by step. Who brought you the documents of the purchase of the asset purchase agreement?
The documents come as supporting documents for the executive finance to release payment. So it was part of the supporting documents validating this transaction.
Okay, but are you in a position to tell us a specific person that brought you the document? That's what I'm asking you.
Okay, I can then mention Ms. Dunaiski because she was the preparer of the document.
Okay. I earlier on asked you whether there is a document, a board-approved document to show that that was approved, the purchase of the assets of 53,212,000.
Your Worship?
Your Lordship, that was not the question. The prior question was not specific whether or not there is a document evidencing an approval by the board. It was just general. It was any document.
Councillor?
I'm being specific now. Let me put it this way. Yes. Now, ma'am, let's start with the first aspect. Was it budgeted for as required?
My answer is yes.
Okay.
It was budgeted for under asset acquisition and business development. And
Okay.
the submission from Ms. Dunaiski stated that these assets were budgeted for. So yes, they were budgeted for.
Was it approved by the board?
No. If a budget is approved by the board, Your Worship, you don't go back to the board and ask again for approval. The board gave you the go-ahead to expend during that financial year. That is the purpose. Board is not responsible for operational management of the organization. They are responsible for the strategic, and this falls under operational. So once the board gives you that approval, you proceed to execute. You don't go back again and say, it's now time to execute.
Okay, but then because for me, I'm speaking with regard to what the document says. In brackets, it says board approved. I'm asking you whether there is a specific board resolution document.
No, there was not.
There was not.
No, there was not.
Okay. Now, what?
The witness, I believe, was still busy testifying.
Okay, you can answer if you had anything to say.
On the basis that this was budgeted for, but also on the basis that I had an asset purchase agreement that is approved approved by the managing director. That asset purchase agreement, the managing director has authority to enter into agreements of any amount in terms of the schedule of authority, the very same document you are reading. So as a result of that, again, we did not need to go to the board. The asset purchase agreement duly authorized that gave the managing director the authority to enter into agreements on behalf of the trading company for any amount. I relied on that also to proceed with the payment. So we did not need to go to board. The managing director already has the authority to enter into this agreement, and this agreement was signed by him. So I proceed to release the funds.
Wasn't there a duty on you as the Executive for Finance and Administration to ensure that documentation with regard to purchase of assets was actually complied with before the funds were eventually released? Wasn't there an obligation on yourself?
Yes, there were.
Okay.
And the obligations are as follows.
Yes.
The requesting department going to the MD, and the MD approves. That's the submission. That's the internal memo from Ms. Dunaiski. The engineering department confirming the existence and the value of these assets, supported by an independent consulting engineer, Sales Consulting. I have that. Then the financial viability or feasibility document that states that this project is viable. I had that. Then I had the asset purchase agreement itself, and within that agreement there are 3 clauses. One that says, make sure the assets are not encumbered. Make sure the ownership of the assets belong to Anacon. Make sure you pay into 2 accounts. One, account 520, and make sure that that money gets back to Namcor. And account 848, make sure that money is paid to Anacon. So those were my assurances that were in front of me before I made the payment.
Okay, we have already established that there was something called the credit committee. Now, I just want to find out something from you, ma'am. Was it just on you to approve, specifically with regard to the asset purchase agreement? Was it just you, or was it also in consultation with other members of the credit committee? And I'm specific, the commercial manager, Ms. Olivia Dunaiski, and Mr. Willemse, the manager for logistics.
That is where...
Just for clarity, so that we are not caught sidelined, is my learned friend proposing to the witness, Your Worship, that it was in fact the credit committee constituted by the individuals that he named who approved the asset purchase agreement, Your Worship? I just want that sort of clarity.
You can respond, but if I understand, you did not make reference to the asset purchase agreement.
Yes.
So do you have any response from him?
I'll just leave the question as is.
Would you just repeat so that I can get you clearly, please?
Yes.
Okay.
The question was, if I can,
Yes.
was it just for her to approve,
Yes.
or was it for her in consultation with two? Just, I'm still finished.
No, I understand. I'm rising so that the court addresses you, Your Worship. Yes.
So that, or was it for her in consultation with accused number 2 and number 4 to approve?
So the question, Your Worship, the clarity sought is approve what? That's why I said, is it to approve the asset purchase agreement? Is that the suggestion, Your Worship? That's the clarity I see.
Okay.
It was actually the credit limit, because I think it's a question that I wanted to ask earlier on, but I just realized that I didn't ask it. So I'm asking about the credit limit, not the asset purchase.
Your Worship, can the question be repeated again, please?
The question is with regard to the approval of the credit limit. Was it only you responsible to approve it, or was it you in consultation with accused 2 and accused number 4?
Yes. So with regards to credit limits, because I was paying attention on the assets. Okay, with regards to credit limits, the approval is in terms of clause 5.9 of the credit policy. The executive finance, which is me, the executive downstream supply and logistics, which is accused number 2, and the managing director, accused number 1. Accused number 4 is part of the credit committee as a commercial manager. She then submits the request for credit.
Okay. Now, with regard to that aspect, I know I'm going back to that aspect, but the aspect of the credit policy. What would your comment be when I say, look, you as the executives, the 3 executives for now at least, you, Ms. Jennifer Hamukwaya, Ms. Olivia Dunaiski, and Mr. Willemse, took these bogus decisions as self-enriching executives. You bypassed the procedures and the rules just for your self-enrichment.
May we ask with respect that whenever my colleague asks a question, he must think about us, that we want to know what he is going on about. He now is talking about took these decisions and refer to them bogus. Now, we do not know in this respect whether it's a matter that pertains to my client, to a particular charge against the accused person, or we don't know what. He's just all over. What is he trying to say? If he can just be fair, specific, and to the point, what is he talking about? Which decisions he's talking about?
Just, Your Worship, as my colleague Rose, I wanted to object, of course, because Counsel for the State says the applicant, 5th applicant, together with accused number 2 and 4, they bypassed, meaning violated. I think it's fair that counsel will refer to the court which policy was violated or bypassed, and specifically which clause was not complied by the applicant. Please, the court, Your Worship.
Any response?
It is being suggested I'm all over, but well, I'm saying the bogus decision that they took to bypass the policies, and by the policies I'm referring to the credit policy, and the decision is that what they bypassed is the credit policy, specifically .3, which says every customer must be assigned a credit limit. And I'm putting this in context because when we have regard to the fuel supply agreement, it had a credit limit. So I'm saying the applicant that is before court now testifying, Mr. Willemse and Mr. Dunaiski, actually took these bogus decisions and bypassed the policies as it says in the
It is not
policy.
Ms., but actually, not Mr., but Ms. Dunaiski.
Maybe it was a slip.
slip of the tongue.
Okay.
Innocent
Then-
slip of the tongue.
Yes, then that is in order.
Yes. Yes.
Ma'am, do you have any comment?
Your Worship, correct, every customer must have a credit limit. But I have read in the credit policy the authority for us to exercise our judgment, as it said there. Decisions must be based on subjective factors, and one of that is the customer's ability to pay. I've also read, Your Worship, clause 5.4, where even though a customer is not due to pay, they can exceed their credit limit and they were allowed to get product on credit. So there was nothing bogus about it, and there was nothing favorite to one customer. They were all treated equally, Your Worship.
And I would also like to put it to you that you, as the chairperson, specifically, the chairperson of the credit committee, and those that were in the committee with you, and I'm referring to Mr. Willemse, Cedric Willemse, and Dunaiski, did not exercise due diligence. You run this credit committee as if it was a child play. You did not exercise due diligence as you were required to.
Can I answer? Your Worship, that is not correct. In the definition of due diligence is also the ability to be transparent. When these customers defaulted, in terms of the credit policy, we were asked to submit to the board and to EXCO, and we did that on a regular basis, without hiding Anacon, without hiding Erongo, and other problematic customers. In that instance, Your Worship, we were due diligent, and we exercised the with due care in terms of the credit policy that was approved by the board.
There is an issue of a credit guarantee. Are you aware of that?
Yes.
Okay, what is a credit guarantee in regard to this case?
So basically, it means that if the customer the customer can give a guarantee, and in the event that they default, Namcor can recall that guarantee to pay what is outstanding.
Correct me if I'm wrong. It will be almost like security that if you don't
Correct.
pay, I'm going to take this.
Correct.
Okay. Now, is it not correct that on 15 December 2021, the credit guarantee was zeroized, meaning it was cancelled?
For who?
15 December
15
2021.
Yes.
For which customer, Your Worship?
Just for Anacon. If you can recall.
I can't recall.
Okay, but if a credit guarantee is zeroized, it means a customer has to pay up before you advance them a product, isn't it? Cash on delivery.
Your Worship, I need clarity here.
It's becoming difficult. This is about my is my colleague putting a legal proposition to the witness, or is he taking it from witness testimony tendered in court? What is he trying to put? If he's is a legal proposition in the principle, he's wrong. If it is evidence, may he tell us whose evidence is that?
Counsel?
I'll qualify the question. So, ma'am, I'm saying the investigating officer will come and testify that he, during his investigation, uncovered that to zerorize a credit guarantee means you must pay before you get a product. Are you aware of such a concept?
No.
Okay. And let's get to the 520 account, the Anacon account. Is it correct that you got access to that account in October 2021?
No.
I'm just not sure of the date.
No.
Okay. When did you have access to the account?
When I was given authority to have access to that account, and that is when the fuel supply agreement was signed on the 16th of March 2022. In that agreement, there is a clause that says I can be a joint signatory. So before that date, I could not touch that account.
Well, the investigating officer will come and testify that already in October 2021, before the fuel supply agreement, you actually had access to the 520 account.
I don't know how to explain this, but the 520 account was opened in 2021 based on the negotiations, okay, that the intention of Anacon to buy. We agreed. There is a board resolution for Anacon, which I signed when the account was opened. Did I have access? Yes, I had access. But I'm not an employee of Anacon. I'm an employee of Namcor. And Namcor only gave me authority to touch that account on the 16th of March 2022 when the supply agreement was signed. Before then, although the account was open, I couldn't touch it because I wasn't authorized to do so.
Well, that's what you are saying, but I just want to alert you that he's coming to testify to that aspect, that in fact, this was actually carefully planned so that you have access to the 520 account before the fuel supply agreement. That's what he's coming to testify.
In order to do what?
You
Sorry, Your Worship. Sorry, Your Worship. Sorry.
You can comment if you have any
Sorry, Your Worship. He can
order.
come testify, Your Worship. That is my position.
Okay, so, in fact, with regard to that aspect you were asking, this will come and show how you actually conspired with the executives of Anacon for you as just a small screen to have access to that account way before the fuel supply agreement. The executives of Anacon.
Mr. Namanja?
Anybody with a knowledge of what conspiracy is would know that when you make allegations relating to conspiracy, you got to be specific. My colleague now is no more talking about directors. He's saying executives. Can he be specific? Is there somebody else? Because if he's talking about executives, I appear to understand that he's talking about someone else other than my two clients. Can he just be specific so that we can come and deal with this investigating officer? It appears what is being put to the witnesses related to management, fine, but we want to be sure so that we address it with the investigating. Who is in the executive is my colleague referring to?
Just in amplification, you will remember, Your Worship, that time and again, when we dealt with the rather weak charges that the state has proffered, we directly went to the Anti-Corruption Act, Your Worship. And the conspiracy crimes, Your Worship, are confined to that act. So also, in amplification, Your Worship, my colleague should also demonstrate which crimes, in terms of the Anti-Corruption Act, the accused are alleged to have conspired to commit, Your Worship, not the fraud and the theft and these fancy things that the state has proffered, Your Worship.
Advocate Lunga?
Thank you, Your Worship. I also don't think there is any necessity to make subliminal remarks of saying, well, anyone with the knowledge, if the question is not clear, I think it's just sincere to ask in a polite manner, because I do not want to venture into that as well. By that, I was referring to the directors of Anacon, if the word executive is the one that is at issue here.
And any response to Mr. Casper's aspect?
I do not think there is any courtesy to reply. There is no need to reply to that. I will not reply to that. Because if they are saying they are weak charges, what do I say? We say they are strong charges, so that's why I'm not replying to that.
Okay.
Yes. So my question was to say, well,
No, but then the issue of Mr. Namanja is answered because you are saying not executive, but the directors.
yes, I think the problem was the usage of the word executives, but it's directors.
Okay.
Perhaps it was just a usage of a wrong word.
Okay. The
Yes.
court will allow the question.
Yes.
Yes. Ma'am, any comment?
Your Worship, the beauty of bank statements is that they are audit trails. So the investigating officer could have requested the audit trail. When did I start transacting on that account? And which amounts did I approve on that account? Investigating officer could have digged a little bit deeper. He would be able to see the audit trail. So even though I had access to the account, my authority only started when Namcor entered into the agreement, and the audit trail of those transactions are available. That's my answer.
On whose
Council, just slow down.
apologies.
We can proceed.
Yes. Ma'am, on whose instructions were you acting when you then had access to the 520 account?
On the authority given to me in terms of the fuel supply agreement, that when money comes into the 520 account pertaining to the fuel, purchase of fuel, I must transfer it to Namcor Trading. So on the authority given to me via the fuel supply agreement duly signed by the managing director.
And we have already also established that Anacon actually had another account, the 848 account as we have called it. And you had no access to the 848 account.
No, I did not.
Okay. Just enlighten us. What was the specific purpose you said for you having access to the 520 account?
I want to refer you to the fuel supply agreement.
Yes.
On the bundle is page 185. Clause 4.5.1.
Clause 4.5.
I believe so, Your Worship. I just need to get there. It's on page 180. Sorry.
Just take your time.
Fuel supply agreement.
Is it not the page 185?
It starts on
185.
185.
Indicated 185, which is
It
correct.
starts on 185.
Yeah.
Yes, sorry, it's close 3.1.2.2 on page 189. On page one, can I read the clause?
189.
189, Your Worship.
Yes.
The parties agree. The parties agree that as additional security, Olivia Hamukwaya, Namcor Executive Strategic Finance and Administration shall at all times remain an A signatory to above bank account for the duration of this agreement, and that all transactions made in the bank account requires her signature and authorization. Should Ms. Hamukwaya leave the employ of the seller, that her successor shall immediately be appointed as an A signatory to the bank account. So it wasn't me, it was the position that I held.
Okay. So I just want to find out something. It says shall remain an A signatory to the above bank account. What does that mean?
I think there are criteria, limitations. So maybe, I don't know, just to approve but not to load. I can't remember off the cuff, but my access there was to simply, once the payment is loaded, to release it into the Namcor trading account.
Okay. So, correct me if I'm wrong. So, if the Minister of Defense wanted to buy fuel, they would issue a purchase order to Anacon, correct?
Yes.
Just pause. You can proceed.
Yes, and then that's when Anacon will then procure fuel from Namcor.
Correct.
And then Anacon, once they've received payment from Ministry of Defense, will then pay into the 520 account.
Yes.
And then that is the account you had access to.
Yes.
I just want to understand something. So you had access to the account, but then it appears, as I've already put to you, that actually the debt actually escalated. Did you realize that there was at some point no money being paid into that account?
Yes, in
Okay.
late 2022.
Okay. Did you inquire from Anacon?
Yes.
What was the reply that you got?
They were not paid by defense.
Are you aware that despite that, I can show you the 848 account, but I just want to put it this way. Are you aware that some amounts from the Minister of Defense was actually being paid into the 848 account?
Yes, Anacon informed us that they have two accounts at the Ministry of Finance.
Yes.
And sometimes finance will pay into the 848 account instead of the 520. They formally informed us about that. We were aware.
Okay. Did you not find it strange, if I can say, that they had actually played you, if I can call it that, because the initial agreement was that money should be paid in the 520 account, but yet the money was being paid into a different account.
I did not know that the money was being paid in the different account because I don't have access to that account. I can only make an informed decision based on what I have access to. I don't have access to 848 account.
From March, 16 March 2022,
Yes.
when the fuel supply agreement was signed, when exactly did you realize that some money, let me say, yeah, money, not some, money was not being paid into the 520 account?
In late 2022.
Only?
Yes, because there were money coming into 520, which I released to Namcor bank account. The money that I read equating to 10 million was from the 520 account. During that period, that was from July up until October. Money was coming to the 520 account. So I didn't worry about accounts that I had no access to.
Okay, and you just told us that it was 10 million that you had realized that had been coming into the 520 account.
I added from July till October that it was about 10 million.
Okay. But then you are aware that, in fact, Anacon was not only indebted to Namcor for the amount of 10 million, it was actually 35 million.
35 million did not just accumulate once. 35 million is as a result of them buying on a monthly basis.
Yes.
And on a monthly basis, they were paying, as was demonstrated in account 520. That 10 million is not a once-off payment. 10 million accumulated from July up until October. So the account was being paid. It came into default starting, I think, around October. We have to see the statement of accounts of Anacon. I can't remember off the cuff.
Yes, but then my concern exactly what I'm saying. Well, you are saying from your calculation only 10 million was paid into the account.
Over a period of time.
Yes, but I'm then telling you that, well, they didn't just owe 10 million, they owed more than 10 million. So why would they only pay 10 million into that account?
That is why we put the account on hold.
Okay.
When we realized that they were not paying.
Can you just bear with me?
Take your time, Councillor.
I would like to the court to have regard to Exhibit B2, which is the Enercon 848 account.
Mr. Million Officer, can you help me here? Exhibit?
B2.
Can you check
B.
Containing the financial statements. B.
B.
B. I think B. And the other one? I can see that one is written D, but we need B for Bernard. Yes. Yes, we need B for Bernard. Yes. Exceed. It's not there. It appears he cannot locate it.
Can
A short break.
okay.
Yes, because the exhibits are already part of the. Yes, the court will then briefly. just be patient. We had a slight power failure. So. We can proceed.
Mr. Court, please. Now, ma'am, I just
What is
want
exhibit. We stopped at exhibit B2.
B2, yes.
Yes.
May I proceed, Your Worship?
You can proceed.
Yes. Now, I just want to tell you that from this document, I just want to. Yes, okay. All right. From Exhibit B2, the period starting from 1 March 2022. Do you see that?
Yes.
On the first page of it, it
Yes.
has 13 pages. To the last page, I have calculated that the amounts of money that came from there, with the reference GRNMODEFT, is a total of 30,533,386.90. And then from the account to which you were the A signatory, which is the 520 account, which is exhibit B1, as you have also already confirmed, there was only 10 million that went into that account.
Can my colleague just keep what the witness said? The impression is not, it's not that that was the only amount. The witness was very specific from around July to October 2022. I think if my colleague can just stick to that period so that it's very clear he's talking about that period. I think that is what the witness said.
No, I think perhaps we are on different things. I'm saying, from me looking at the document, 520, the B2,
Yes.
not 520, 848.
Yes.
From 1 March
Yes.
to the last page of that document. Unfortunately, my part is cut, but it's a date in November 2022. I'm saying the money,
How many pages do you?
it's 13 pages of B2.
Yes, we have agreed on record. The document indicates 13 pages, but the last page is only 10 of 13. Can you just confirm whether
the
you
one-
have 13 pages?
Mine has 13 pages.
You remember that when the court had given my learned friends for the state the opportunity to go and sort out those documents, when we came back, the observation that all of us made together with the court
Yeah.
is that we are also only in possession of that document that is bearing the 10 and the
10
13
of
next to each
13.
other at the last end.
Yes.
Worship, I do not want to blame my colleague, but I think that was dealt with by Ms. Hinda, and I do not want to
Okay.
blame her. It was just perhaps an oversight, and I do not think it was maliciously done not to disclose that last page.
Yes, so what is your
Yes.
version? Yes.
So my version, I'm saying, from the documents that I have,
I think there is something that was left.
Yes,
And just so that we are all on the same page, it's not that we are objecting.
yes,
We just want the witness
Record.
statement to be placed correctly to the witness. Because my learned friend referred to 520
yes,
and made a statement that the witness said that only 10 million was paid into that account.
yes.
Mr. Namanja then raised given that the witness testimony, Your Worship, was that she confined that assessment she made to the period July until, I believe, October.
Yeah.
So that the witness is just given the question in the context with her testimony, Your Worship.
Counsel?
I'll break it down.
Okay.
So from July 2022 up to, I think, October, if I'm not wrong.
Yes.
Are you with me?
Yes.
Yes, we have established that 10 million was paid into the 520 account.
Yes.
To which you are signatory.
Yes.
Okay, and then Exhibit B2, which I have, of the 8, which is the 848 account of Anacon as well. When I calculated the money that went into that account from the 1st of March 2022 to end of November 2022, the money that came into that account with the reference, just want to complete, GRNEFT MOD, specifically with that reference, totals to the amount of 30,533,386.90.
Yes.
With that being said, ma'am, wouldn't you find it odd that in an account to which you are a signatory, the A signatory, which was the account that you had agreed that the money being paid would come into there, was actually not paid, but a lesser amount was paid into that account? Don't you find it odd? Or
I can't comment on the oddness.
yes.
This account I have no access to. But you gave me this account only 5 minutes ago, less than 5 minutes ago. And I went through it just to see. On this account alone, there were also payments made to Namcor directly. Within 5 minutes that you gave me.
Well, that,
So,
that document is with your
Can-
lawyer.
can-
I don't want,
No.
want
Yes,
to,
can you
to
maybe
be-
just let
yes.
her finish?
So,
Okay.
Yeah.
of the 30 million that you added, 10 million going to 520, there were direct payments to Namcor from this account. I just checked about 5 transactions that went to Namcor directly. So that 30 million statement, although correct, factually not correct. I want to demonstrate, Your Worship. On the second page, the date is skewed, but it's the second page, the first transaction. I think it's a 9/03/2022. Namcor was paid 1 million.
On which?
The second
exhibit?
page.
Which exhibit?
Exhibit B2, Your Worship.
The second page.
Yes. I just went through this now. The first transaction, Your Worship, on that second page, it's $1 million paid to Namcor.
Just hang on before you respond. Your Worship, I think we are not on the same page with the witness. Firstly, I think with regard to the bank statement, that statement was disclosed to Mr. Bangamavo, so I cannot be faulted that I just gave it to him now.
Okay.
If he didn't go through that document, I do not know.
Okay.
Also, secondly, what I'm asking is the money with the reference GRNMOD EFT.
Yeah.
That's what I'm concerned with,
Yes.
not the money with that says Namcor Bank.
Okay.
No, not that. I'm not concerned about that.
Your Worship, can I answer? I want to refer you to the third, it says page 4 of 13, Your Worship, of the statement. On the 9th of May 2022, it's just one example. 9th of May 2022, transaction code 106, Your Worship.
Yeah.
GRNEFT 08MOD/733083 paid into this account $1,894,045.14. On the same day, Namcor was paid $938,850.
Mr. Hamukwaya, I think you are misunderstanding me. You see, what I'm trying to say, remember, let me take you a few steps back. I was saying, the initial agreement between Namcor and Anacon was that you had to be a signatory to the 520 account. Do you get that?
Yes.
Yes, and that's where Anacon was to pay in money for you to observe that money was being paid.
Yes.
You agree?
Yes.
Okay, so I'm saying Anacon had also another account, the 848 account.
Yes.
And I'm also saying, despite that standing agreement between Anacon and Namcor, that money was supposed to be paid into that account when they receive money from Ministry of Defense. You get me?
Yes.
I'm saying more money went into the 848 account with the reference GRNEFTMOD. More money went into the account as opposed to the 520 account.
Correct.
Yes.
And the explanation was provided.
Which is what?
Enercon submitted 2 accounts to the Ministry of Finance for payment.
Yes.
Enercon informed us that they have submitted those 2 accounts. In the event the ministry pays into the account of 484, they will transfer to account 520. They informed us of that and we were aware.
Okay. Now, I just want to alert you or to tell you that you recall the 35 million amount that Anacon paid to Namcor. And what I've just told you earlier is that in this account, the 848 account, which is Exhibit B2, the total amount that was paid there is the 30 million, which is actually close to the 35 million that Anacon owed to Namcor. Do you see that?
One has nothing to do with the other, but okay.
Okay, all right. So I'm just telling you that although you have said it's not odd, I find it odd that, look, Anacon owed Namcor an amount of 35 million, but when money is paid from the Ministry of Defense, instead of that money being paid into an account which you have access to, it's actually paid into a different account. And you are saying you don't find that odd.
Your Worship, just for the record, and I think we must at all times be fair. Your Worship, you will recall, I believe it was the second bail applicant. When he testified, Your Worship, he equally testified to the fact that they had 2 accounts, the 520 and the 848. You would also recall, Your Worship, and it is really only correct that when my learned friend puts a proposition to the witness, particularly emanating from the evidence, that the evidence be put to the witness as it was tendered in this court. You would then remember, Your Worship, that the second bail applicant then tenders testimony to the fact that in the event that payments were being made into the 848 account, they would pay over those amounts from 848 into the 520 account. Now, Your Worship, you would also remember when this witness started to engage with the activity of this bank statement, the witness made attempts to point this court to payments that come from this account to Namcor, Your Worship. So the context is certainly important, Your Worship, and that context must be placed to the witness to give a comment on, and not in isolation, as my friend, learned friend is doing here, Your Worship, to suggest as if when this money came into 848, this money never went to Namcor, Your Worship. That's in essence the suggestion that the state is making, which is patently wrong.
Any comment?
I do not have a comment. I think the documents speak for themselves. I'll argue that point. I think I've tried to demonstrate what I find odd. And I think it's up to him to argue if he wants that way. But I'm saying from the standing agreement between Anacon and Namcor, money was supposed to be paid into the 520 account.
Yes,
but
I understand he's only concerned about the context, which I understand.
Yes.
Ma'am, do you have any comment?
The question, Your Worship, what's the question?
I was saying, I find it odd, although you are saying you don't find it odd that more money was paid into the 848 account. Do you have a comment?
On the oddness, no.
Okay. All right.
On the statement providing evidence that although government paid into the 848 and Anacon paid from F848 to Namcor, that is evidence that is presented here, Your Worship. I can't, the oddness I cannot, that's someone's opinion.
Now, Mr. Hamukwaya, you also aware of the fact that your husband, Mr. Panduleni Hamukwaya, owned Panduleni Farming CC.
Yes.
And do you own any farm in Grootfontein?
I don't own it. The farm is owned by my husband.
Okay. Did you forget to mention that when you testified, perhaps, maybe? Because you did not mention it.
Because it's not my asset.
All right. You don't co-own it with your husband?
I do not. What I co-own is the house, not the farm.
All right. So when you left Namcor in April 2023, or let me put it this way, before you left Namcor,
Yes?
Mr. Panduleni Hamukwaya was the 100% owner, or if I can call him that, in Panduleni Farming CC.
Yes, that's correct.
Okay, and then in April, when you left your employment with Namcor, is it not correct that then you became a 50% owner in Panduleni Farming?
That is correct.
Okay, so I just want to understand from the bank statement of Panduleni Farming, which you also have access to.
Yes.
Your Worship, that will be Exhibit B6.
Can I have a copy?
Do you have it with you?
I don't have a copy.
Maybe Mr. Bangamavo can donate his.
It's a page, Your Worship. The bundle, Mr. Hamukwaya, the bundle before you, go to page 339, Your Worship. 339 up to 344. Did you get it? Yes. Please, the court, Your Worship.
Okay, so, Mr. Hamukwaya, I just want to refer you to the transaction on that document of 20 July 2022, yes. Transaction code 107, with the description quality meat supplies. Do you see that?
Yes.
An amount of 500,000.
Yes.
Okay.
Just a minute, at what page of that document?
It's the first page. Page number 1 on 20 July.
20 July.
Yes.
Yeah.
B6. Okay, so do you also see that on 5 August 2022,
5 August 2022.
yes, just before I go to that aspect, I just want to tell you that before the 500,000 actually came in, the closing balance was $17,651.79.
Yes.
You confirm that?
Yes.
Okay, and then thereafter on the 20th of July, 2022, 500,000 was paid into that account from Quality Meat Supplies.
Yes.
And then, do you see that on 5 August 2022, transaction code 155, there was a
5 August
2022. There is a description agribank payment.
Yes.
And then an amount of 107,663.95 was paid to Agribank.
Yes.
Okay. And you have heard from the evidence that was led when, for instance, accused one.
Accused one, which applicant?
My apologies, not accused one, but the first applicant, Mr. Peter Elindi.
Yeah.
Yes. Amongst others, he was asked about quality meat supplies.
Yes,
Do you have any connection with quality meat supplies?
I do not.
Do you know who owns quality meat supplies?
At the time, I did not. I was informed that it's Mr. Victor Malima.
Okay.
Yes, Lord. Yes.
Do you, that is if you know, do you know any business that Panduleni Farming CC was doing with quality meat supplies?
Yes, it was selling meat to quality meat supplies.
If you can comment, the investigating officer will actually come and testify that this quality meat supplies was actually a briefcase company, if you know what that is. It was something that is almost non-existent, although it exists. What is your comment?
I don't know about it.
Okay.
The business dealings with quality supplies was not with me.
And I'll put it to you that the money from the 500,000 that was paid to quality meat supplies, it's actually money that came from, just want to lay the proper basis, Your Worship, if the court can just bear with me.
Take your time.
Yes. So what I'm putting to you is that the flow of the money was as follows, and you can comment if you want. So the money, firstly, it was the 53,212,000 that Namcor paid to Anacon. You got that?
Yes.
And then 35 million was then paid to Namcor
Correct.
by Anacon.
Correct.
And then an amount of 18,212,000 remained from that total amount. And then 9.5 million was sent to Eco Trading, an entity owned by Victor Simaneka Malima. And then from that amount, Quality Meat Supplies then received 1,470,000, of which we are saying Panduleni Farming actually got 500,000. That's what we are saying. Would you dispute that this was the way the money was laundered, as we are trying to show? That the proceeds that you actually received, the 500,000, was not because you were doing business, but it's just money that was received from that amount.
Objection, Your Worship. Please, the court, Your Worship. I think it's important that the state sticks to the evidence before court. The bank statement, everyone who testified, Your Worship, no one demonstrated that the applicant, the witness, has received 500,000. Please, the court, your worship.
Counsel, any response?
Well, Your Worship, for me, I'm putting it as evidence that will lead, and I think it's prudent for me to put it before this witness instead of waiting for the investigating officer. So if she's in a disagreement, she can say so. But this is what we are saying as the state.
Okay.
Yes.
Counsel, I understand your position, and the objection, if it's an objection, is overruled. You have any comment?
Your Worship, the business dealings of Panduleni Farming and the management of Panduleni Farming lies solely with my husband. He deals with all the sales pertaining to farming activities. So I'm not involved in any of those business dealings, Your Worship.
We can proceed.
And then I'll put it to you that as per the bank statement, again on 5 October 2022, an amount of 100,000 was again received by Panduleni Farming, which money came from Quality Meat Supplies. Do you see that?
Yes.
Okay. And then, in fact, again on the second page, on 26 October 2022, transaction 102, again, an amount of 100,000 was received from Quality Meat Supplies. You see that?
Yes.
And in fact, in December of that year, on 17 December 2022, transaction code 107, again, another amount of 500,000 was received.
Yes.
From Quality Meat Supplies. In fact, if my mathematics is correct, an amount of at least 1.4 million was received at least from Quality Meat Supplies by Panduleni Farming CC.
Yes.
And what we are saying as the state, if you can comment, we are saying these are the proceeds of the money that was paid by Eco Trading to Quality Meat Supplies, which money then eventually found its way into Panduleni Farming CC.
As far as I know,
Yes.
Quality Meat Supply was doing business with Panduleni Farming. And the business dealings are done by my husband. But you are only pointing, in addition to that, you are only pointing to Quality Meat Supplies as if these are the only incomes that are coming into this bank account. That is not true. There are other incomes coming in, not pertaining to Quality Meat Supplies, just looking at the bank statement, not going into the activities. But you are only highlighting Quality Meat Supplies, so as to say it's only meat supplies that's dealing with Panduleni Farming. But there is farm equipment, 80,000 that came into the account on 27 April 2022. I'm trying to demonstrate to you that it's not just meat supplies, it's other incomes also into this account. So these were done, as far as I can see, just based on a bank statement. These are farming activities done in the ordinary course of business between one farming company to another farming company. But like I said, the dealings are solely with my husband, not myself. I'm just pointing to you that there are other incomes in that account as well.
And what we are saying, the investigating officer will come and testify, is that because of your position at Namcor at that time as the Executive for Finance and Administration, you dubiously approved the sale of the acquisition of the bulk fuel storage facilities in order to also receive money in the amount of 500,000 as gratification, which went to your husband's CC.
I have to stand to protect the applicant.
Yeah.
Yes, Your Worship. And this is very serious, actually, because State Counsel, as an officer of the court, has a duty to put facts which are consonant with the evidence before court. Your Worship, before court, the asset, the State Counsel said the applicant approved the purchase of bulk storage facility. That's not correct, Your Worship. She testified and told the court she was never part of negotiation, discussion, conclusion, and signing of that asset purchase agreement. Nowhere on that asset purchase agreement her name appears. Nowhere on that document, at page 51, Your Worship, the name of Jennifer Hamukwaya and the signature appears. She told the court that contract was drafted by the legal department of Namcor on behalf of trading and distribution. For the State Counsel to say that the applicant dubiously approved the asset purchase, that is incorrect. Please, the court, Your Worship.
Any response?
Yes. Your Worship, I think from the onset I have tried to demonstrate that Your Worship will remember from the schedule of authority when I was trying to lay the basis that there are assets that should be bought with board approval and the role of the credit committee. So my question is premised around that, to say the accused, as the manager for finance and administration, should have exercised due diligence to ensure that these assets are not sold without, not sold, but bought first by obtaining board approval. So I'm saying, because of her position that she occupied at Namcor, she failed to exercise due diligence as was required of her, and she approved this so that she can get gratification in the amount of 500,000. That's where my question is premised around. And I think if she has a comment, she can answer, because I think I've laid sufficient basis on which I'm asking the question.
Yes, but her concern is
Yes.
on the approval of the asset purchase agreement.
Yes.
I understand you to say you are leaning more
Yes.
on the payment, if I'm correct.
Yes, on
of
the payment.
53 million.
Yes.
Do-
The payment, yes.
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 But his concern is the asset purchase agreement, which word you have used.
Well,
Do you see? Mr. Bangamwamba rose to say
yes.
she has no part to play in the asset purchase agreement.
Okay, I understand. I'll take off the aspect of the purchase agreement.
Yeah.
Asset purchase agreement. I'll put in the issue of the money that was released from finance where she was employed.
Ma'am, then the court will allow that aspect.
Yes, Your Worship, according to the bank statement, that 500,000 that was paid by Quality Meat Supplies, Your Worship, under the debit side, there is no amount that came to me. These were payments done as a result of receiving money from Quality Meat Supply. The following transactions pertains to farming activities. No money came to me, and therefore I did not receive any gratification. You can also see, Your Worship, that there is no withdrawals. All these payments were directly linked to a payment of a farming activity. So I did not receive gratifications, and I did not benefit from the 500,000 from Quality Meat Supplies. Your Worship.
We can proceed.
Yes. Now, I also want to put it to you that, you see, from the bank statement, is in as much as you are distancing yourself as far as possible from this, you are saying, because Mr. Panduleni Hamukwaya is your husband, who was the sole member of this CC. He benefited because of the virtue of your position at Namcor.
Objection, Your Worship. There is the problem. If we were to be responsible for the conduct or the action of our wives and their husbands, I think that will be a big problem. There will be chaos. There is no way in the world where criminal liability and prosecution can be based on the conduct of another, meaning vicarious criminal liability. I never heard of that. But that will be for argument purpose, Your Worship. Please, the court, Your Worship.
Counsel, any response?
I'll leave it for argument, Your Worship.
Okay, then we can move on.
Yes. So, ma'am, I just want to get to another aspect. The court can just bear with me, Your Worship.
Take your time, Counsel.
Yes. So I just want to understand something, just to clarify from you. So there was a name mentioned, Sam Hashela. You remember
Yes.
that?
Yes.
And he is the person that compiled the discounted cash flow.
Correct.
I just want to understand who arranged the meeting or the instruction to tell him to compile the discounted cash flow.
The requesting department,
Which is which one?
marketing, sales and marketing.
So, okay, I'll ask it differently. So
Okay.
I just want to understand also, with regard to Anacon, the fuel supply, did you ask for a financial statement of what you have called liquidity? If I get it, that's what you have said earlier on, before you entered into the fuel supply agreement.
Yes.
Your Worship, otherwise we will never finish this bail application if the rules of evidence are not going to be complied with. The last question pertaining to my client's company, of what relevance is it? My colleague has been going on and we have been trying not to disrupt cross-examination so that when we cross-examine the investigating officer, our colleague gives us the same courtesy. But, Your Lordship, you have been listening to the statement from my colleague, for instance, asking this witness that you did not do a proper due diligence. So in other words, either accusing the witness of incompetence or negligence, Your Worship, all questions must be asked in relation to the charges before court. When my colleague accuses a witness of negligence, what are you going to do with it, Your Worship? What are you going to do with it? When you say somebody didn't do proper due diligence, you are actually saying you are incompetent or you are negligent. In any way, it's against the state if that is their case. This inquiry, Your Worship, we are not doing an audit whether people at Namcor could do their work, whether they were negligent or they were competent or incompetent. That's not the work of a criminal court. It's a bail application, evidence being heard, relative to the charges before court. So now when we ask the witness, about my client's company, did you ask for a financial statement? So what? If she say no, what is the court going to use that no? If she say yes, it will never advance any party's case with greatest respect. Otherwise, we will never finish this bail application. Accused persons are going on and paying and paying and paying for lawyers to be in court, weeks out, weeks in.
Any response?
Thank you, Your Worship. It was said the relevance, I think on a scale of 5, that is a 5. My question is very relevant. Because, Your Worship, I must put context to that question. Because initially, Your Worship will remember from the onset it was being said this is a commercial transaction which should have not even come to this court. But again, today the witness testified about the issue of liquidity. So I'm establishing that from asking her about the financial statement then, because how then, maybe she can tell us, would they determine liquidity or how? So I think there is nothing unfair about the question. So if they were to determine liquidity amongst others, I think it's just fair that she answers the question.
I think with greatest respect, the point is, let's assume she's saying.
Mr. Namanja, you have raised the point,
Yes.
the objection.
Yes.
He has responded.
Oh, I thought I'm entitled to respond because I raised the point, he
Yes.
speaks, and then I thought I could reply.
Then you can proceed.
Yes, what I'm trying to say, Your Worship, is that the key question is, why is the information being sought? Let's say the witness said, I failed to ask such important information on liquidity. The next question is, how is it relevant to this proceeding? It's not. It's definitely not. Because my colleague is inquiring into diligence of an executive of finance. He's no more trying to lead evidence that she participated in an unlawful activity intentionally. There is no single offense which has an element of negligence on the charges faced by everybody. So we cannot go on like that, with greatest respect.
Yes, Mr. Namanja, your objection is noted. However, it is apparent, as Mr. Mulunga put it, that she testified about liquidity. He just simply wants to know how did they arrive at that point. Yes, therefore the court will overrule the objection.
Please, Your Worship, my objection.
You are raising? Okay, it's a different issue.
Yes, Your
Okay.
Worship, if I may. My colleague is asking for financial statements. Financial statements are usually for a certain period. You should specify for which company and for which period the witness is supposed to have, or what he wants to determine.
Any comment or response?
Well, if it's for the period, it will be from January 2022. Your Worship would also recall that the fuel supply agreement was entered into on 16 March 2022. So if that is what Ms. Gebhardt wants, it's from January to at least March, when not even January will be too soon. From January 2021 up to March, when the fuel supply agreement was signed, that period to determine the liquidity.
Can I have the period again?
January 2021 to March 2022.
There is a problem again. The period of investigation is May 2022 until May 2023. And now the witness being put question relating to a bank statement or documentary evidence well before the period in question. This is not fair, Your Worship. Because that information, like Mr. Namanje has submitted, it's not helpful to the court. It's irrelevant. And we know every lawyer, I think, irrelevant evidence will only create collateral or peripheral issues which has nothing to do with the charges we are dealing with. Please, the court, Your Worship.
Any response?
None, Your Worship. I will not respond. I think I've responded enough.
Yes, the court have already allowed the question. The only issue was with the period. Do you have any comment, if any?
Your Worship, off the cuff, not, but the question cannot be asked in isolation. We follow the credit policy in determining the customer's risk profile. So on, I don't know which page is this, but there's a section in the credit policy that requires, if for example, a customer is under category A, then we request information according to that category. But out of my head, I can't answer that question. We need to see the minutes of the credit committee and under which category Anacon was and what then was required as far as liquidity is concerned. I know there were government guarantees, purchase orders that were required, but like I said, the question is asked in isolation.
Yes,
and
if
it
you
cannot
say
be
you
taken.
cannot answer, then that is
Yes,
your answer.
yes.
We move on.
Thank
Yes.
you, Your Worship.
Yes. We can proceed.
Yes. So I just want to put it to you that you, ma'am, you are not a good candidate for bail, because just like the fifth applicant, I'm not sure if Mr. Mulunga, just like the fifth applicant.
He was the fourth.
The fourth, yes.
Yes.
The fourth applicant. Your involvement is also at the core of this case. And if you are granted bail, you abscond because of your major involvement in this whole case.
Can I answer? My involvement, Your Worship, is very clear. There is nothing ambiguous about it. I was asked to pay 53 million as directed by the supporting documents that were in front of me. I was authorized in terms of the credit policy to give credit to customers. I have demonstrated throughout, nowhere was there an unauthorized transaction. Everything that I did was authorized, and I did it according to the sections or the clauses in terms of the agreements and sections and clauses in terms of the credit policy. Nothing here that I did was not unauthorized.
And I will also put it to you that in the position that you occupied, you let things slide. Terrible financial decisions which you made in order to benefit yourself and those that were under you, that you were with in the credit committee, including accused one as well, the managing director.
I did not let things slide. In terms of debt management, we managed the debt. I've demonstrated that customers paid until the time I left. It is what happened next, what the interim management of Namcor did to bring financial losses to the company. As far as I'm concerned, I did my job to the best of my abilities. I did not bring this organization into financial difficulties. We managed, we alerted those that were charged with governance on the problematic customers, as we were instructed to do in terms of the policies. I paid in accordance to the agreements that were before me. So I did not let anything slide, Your Worship.
And I also put it to you that because of the preferential treatment that was given to Anacon, which was already a bad debtor. Fuel was being supplied despite their having a credit limit, and this was done in order for you and the executives in the credit committee and Mr. Mulunga, also for you to benefit, all of you in the executive at Namcor.
Your Worship, first of all, I did not give preferential treatment to any customer. All customers were treated equally. All customers were treated in accordance with the policies that were there at the time. And at no time did I benefit from any of those transactions, as I have demonstrated.
In fact, even an entity called Irongo Petroleum CC, you recall that entity?
Yes.
You know who was the member in the CC?
I don't know who was a member in the CC. I know who was in charge of the account.
Okay, who is that person?
Mr. Olivia Elindi.
Okay, so I put it to you that just like Anacon, Irongo Petroleum also had liquidity issues.
I disagree with that statement.
Okay.
Liquidity means they are having cash to pay. And I have demonstrated that Irongo, up until the time I left, was paying in the regions of 10, 20, even 50 million. It is what happened next with the interim management when they put this account on hold without understanding the repercussions of putting such an account on hold. That's what brought financial losses.
Okay.
Not liquidity.
Yes, perhaps the word liquidity, but I'm saying it had issues with payment.
They did not.
Okay. The investigating officer will come and testify to that. So I put it to you also that you, ma'am, because the money that is involved here, and by money I mean both money in the asset purchase agreement and money in the fuel supply agreement, was actually lost because you were negligent. You allowed transactions that were even flagged by PwC to continue because it was to your benefit.
At the start of this case, a 480 million was mentioned. Not once did the state refer to the 480. Now we are bringing it to the Enercon transaction and the credit. These were transactions that were done in the ordinary course of business, and I acted based on the documents that were in front of me. That's my comment, Your Worship.
Your Worship, I just want to make sure.
Take your time.
That will be a cross-examination, Your Worship. Step up, please.
Your Worship, it's now 12 o'clock. I don't want us to adjourn for the examination because mine will be very short.
Yes.
Because the applicant's evidence is very clear, backed by documentary evidence. Let me, Miss Jennifer Hamukwaya, let's go to your employment contract. Your Worship, that is at page, the employment contract of the applicant is at page 30. Specifically, I want you to go to page 33. Madam?
Page?
33 of the bundle. That is E2.
Yes.
I want you to read the top, the subheading.
Job description.
Yes, 4.
Job description, responsibilities, and key performance areas.
Yes. Madam, if you go to 4.6, are you
Yes.
there?
Yes.
It's one of your job description and responsibility and duties.
Yes.
Can you read it?
4.6. The executive agrees to obey and carry out all lawful and reasonable orders and to perform such work as he/she is directed and required to perform by the board as represented by MD and board committee structures of the employer.
Full stop. Stay there. Is it correct to say that as far as this transaction is concerned, all issues arising from this allegation against you, that whatever you did, you were complying with this paragraph 4.6?
That is correct.
Are you free to tell the court what would have happened if you were given instruction by the MD representing the board of Namcor to carry out lawful and reasonable instruction and you refuse to do that? What would have happened to you?
That will also be disciplinary action. We take.
Yeah, the same, Your Worship. I want the witness or the applicant to go to page 40 of the same employment contract. Your Worship, specifically paragraph 12, 2.1 and 2.2. Are you there?
Yes.
Yes. Can you read into the record 12.1?
12.1, it's under the heading Grievance and Disciplinary Procedures.
Yes.
The executive undertake to abide by the employer's laid down employment relations.
Counsel, I understand, but I don't know whether that issue arose from cross-examination.
Okay.
I'm just saying whether it arose from cross-examination. If you have the view, you make your position and then...
Yes. Let me ask you a simple question, Ms. Hamukwaya. If, assuming that you violated or bypassed the credit policy or any policy of Namcor, what was the employer expected to do?
In terms of my contract of employment, non-compliance to policies, non-compliance to internal policies and procedures are dealt with through disciplinary action, not criminal action.
That's exactly, Your Worship, where we're leading to.
Clause 12.2.
Yes, can you read that one, 12.2?
Should the executive breach any of the provisions contained in this agreement or included in the common law principles applicable to the employment relationship, such executive shall be subjected to disciplinary action in accordance with the said procedure.
Now, my colleague for the state during cross-examination, he referred you to the outcome of the PwC report. You remember?
Yes.
Of course, there is something, I don't know if it was intentional or maybe an omission, but there is one recommendation which was made by PwC.
Yes.
That the members of the credit committee, if there was any violation of the credit policy, ought to have been brought before a disciplinary hearing. Do you remember?
Yes.
Now, at the time you left Namcor in April 2023,
yes.
Did Namcor or your former employer, they take any action against any member of the credit committee arising from these exorbitant debts owned by resellers?
No, not that I'm aware of.
Mr. Hamukwaya, you are being accused of conspiracy, you are being accused of fraud, theft by false pretense, and receiving gratification, and money laundering under poker. Can you repeat to this court what you said? Did you receive any money from any of the clients of Namcor?
I did not receive any money from any of the clients of Namcor.
Did you hold any secret meetings conspiring with the representative of Anacon, Eronggo Petroleum, or any of your ex-colleagues at Namcor?
No, I did not. In fact, finance is not allowed to negotiate on behalf of the company. It's only allowed to make payments once those negotiations have been completed. So no, I did not.
I think that is the re-examination, Your Worship. Please go to Your Worship. So this brings an end to the fifth applicant's application for bail. And this is the only witness. We don't intend to call any other witness as far as this application is concerned. Please go to Your Worship.
Ma'am, the court has one or two questions.
Yes, Your Worship.
Now, do you know the first and the second applicant in these proceedings?
Mr. Peter Elindi and Malakia Elindi?
Yes.
Yes, Your Worship, I do.
How do you know them?
As the directors of Anacon, when they transacted on the debt session.
Yes, debt session.
On the debt session, Your Worship.
Yes.
I also know Mr. Peter Elindi. He is a friend to my husband. They were in Cuba together.
If you say, Mr. Peter, the court get lost a bit. The easy one is the first or the second applicant?
The first applicant,
The first applicant.
Your Worship.
Any follow-up question?
No, Your Worship. None, Your Worship.
Yes, ma'am, we thank you for your time. You
Your
may
Worship.
stand up.
Thank you, Your Worship.
We can proceed.
Your Worship, in the scheme of things, it would now be Ms. Dunaiski. That would then, in essence, make her the sixth applicant. My numbering is correct, Your Worship. Your Worship, we have handed up our application. It's a notice of motion supported by a founding affidavit with its annexures. Your Worship, it has been served on all councils for avoidance. Yes.
Let me just locate it. another file. This one only is the one for accused number 9. Yes, it was already received by the court, but it's not part of that file. It will appear the clerk of court put them in the files, but that file only is it contained.
I think she just made an error and put it in between.
In between.
Yes,
Okay.
again. It is in there. As it is in the court.
Okay, it was
Yes.
just put in between the files.
Yes, the court, please.
Yeah.
Your Worship, in the interest of time and making progress, given that this is an affidavit under oath duly commissioned and evidence, Your Worship, we apply that that same be received into the record, Your Worship, and be apportioned the correct exhibit number. I think the last exhibit we dealt with was E.
Yes.
E3, Your Worship. Under the circumstances, this can then be received as exhibit F. Yes, the court, please.
Yes. Now, before we proceed, Mr. Casper, counsels, Mr. Lilungwe, also you must assist. Now, seeing that we are on record from the onset, and also seeing that part of the applicants in these proceedings brought their bail applications by way of viva voce evidence, and that this is an affidavit.
Yes.
Ordinarily, in the scheme of work, you have two issues: that where both parties, for example, proceed by way of affidavit, then the court is not sitting, the court just goes through by affidavit, the documents are filed.
Yes.
But now I'm just asking that because we are on record, we have the affidavit before court, and the state already signaled that they are going to proceed by viva voce evidence in response.
Yes.
So the court is of the view that maybe we read the affidavit into the record.
Your Worship, well, of course, we adopted the procedure on the strength of this court's earlier rulings that
Yes.
bail proceedings are sui generis by its very design.
Yes.
We are also equally mindful, Your Worship, of the time that has already gotten lost with the numerous postponements and so forth and so on. So, Your Worship, our procedure
Maybe before
proposed...
you
Yes.
proceed, Mr. Casper, the court just recall it did not mark the exhibit as
Indeed, Your
exhibit
Worship.
F.
Yes.
Yes.
Indeed.
The affidavit for the sixth applicant is then marked as exhibit F.
Yes. And Your Worship, it's part of the record. It is there for any avoidance of doubt. Really, ours is in the interest of fast-tracking this application, Your Worship, so that we may come to a point where we may have the reception of the state's case, and to avoid unnecessary delays, Your Worship, by standing and reading that entire affidavit into the record.
Yes, it's not an objection. I'm just trying to.
Yes, Mr.
Your
Mulunga.
Worship, I think once an application is made and the affidavit as real evidence is handed up for purposes of the proceedings, that is already the record. There is no, unless there is a special reason, there is no requirement that an affidavit be read into the record so that when you have a transcript, again, people will be typing it up. Just like other document, it's part of the record. If it's, for instance, there is a review or an appeal, the affidavit will be there. When my colleague for the state cross-examine witnesses, they will be referring, if he want to read that particular paragraph, that is what happens. But I'm not objecting. We are just trying
Yes.
to manage time.
Yes,
But
yes.
of course, any counsel who want to. But I'm just saying there is no requirement, because the affidavit itself, once it is handed up, that is the record of proceedings. In fact, it's even better, because if you read it in and the people that will be doing the typing up of the record and that do not get it, you will even find that there is a difference between what is read in the record in the affidavit itself. I would suggest that if there is any counsel that wants to hand up that affidavit, there is no prejudice to anyone if there is no reading into the record. But I'm not objecting that someone must. I'm just saying there is no
I
danger.
understand,
As-
Mr. Namanja.
as the
Yes.
court, please.
Any other counsel, Ms. Gebhardt,
Your
are you
Worship.
proceeding on the same point?
Yes, Your Worship.
Okay.
I
Because
will
you are
al-
having a bundle, so I
Yes,
thought you are
Your-
dealing with your
Your
client.
Worship, in respect of my client accused number
That's
9.
why I'm asking. Maybe before we move to your
Okay,
client,
are you
can we
still
then?
busy? No,
Yes.
no, I have no comment on Mr. Casper's way of doing things. I will speak in respect of my client when it's my
Okay,
turn.
that is why I was asking, because I see you having a bundle.
Yes, Your
That, are you
Worship.
moving to your client
No,
before
it's
this
the
issue
same
is
point,
exhausted?
but only for my client. I'll speak when it's that time. If he intends to do it that way, I have no issues.
Okay.
Yeah.
Counsel, no other comment? Mr. Casper?
No
Okay.
other comment, Your Worship.
Counsel?
Yes, Your Worship. I have a comment. I think it is prudent that the affidavit be read into record. I think not just for it was being said time. I think we should not sacrifice for convenience with procedural issues. I think it would just be better if it's read into the record. Because in any event, when the transcribers transcribe, they would not have the affidavit with them. Just for the record to be complete. I've seen that the affidavit actually contains annexures as well. We are not concerned about the annexures, but specifically the affidavit, because that's where the applicant then says on what basis he seeks to be released on bail. So I would suggest that it's read into record. I know it is a tedious exercise, but I think it's just prudent and procedurally correct that it's read into record. Mr. God pleases.
Mr. Casper, any response?
Yes, simply put, Your Worship, you have on numerous occasions directed how bail proceedings are sui generis. And that really relates to procedure, Your Worship. And we have made our election, Your Worship. We intend to proceed on this basis. The affidavit, by being received, forms part and parcel of the record, Your Worship. And that's the election we have made. The court, please.
Yes, it's apparent that it's an application from the applicant, and the applicant have made an election regarding the manner in which they intend to proceed. It's correct, bail is sui generis. There is no strict procedure when it comes to bail application. In fact, case law indicates that bail is easygoing. No rigid procedures. Therefore, the applicant have made an election and there is no prejudice because it's the applicant's position. The document, the affidavit, that Exhibit F, is then received into the record, on which basis the applicant sets out her reasons for formal bail application.
Yes, the court.
That is in order, the court will then proceed.
Your Worship, that would be me then, in respect of accused number 9.
Then before you proceed, then Mrs. Olivia Grace Dunaiski, for these purposes of this bail application, she is the 6th applicant. Yes. Yes, Mrs. Gephardt.
As it pleases the court, Your Worship, the application of accused person number 9, applicant number 7 now, I'm going to read his affidavit onto the record. Before I proceed, I must already indicate that the state has stated yesterday that they will oppose it by way, not yesterday, at our last sitting,
Yes.
that would be Friday. They did intimate that they will oppose it by way of calling viva voce evidence, so that part is taken care of. The second issue I wish to indicate to the court is because the proceedings are being streamed live, I'm going to skip reading the identity, the exact identity number of my client, his passport number, as well as the ERF, for obvious reasons. But if I need to clarify, it's because that information can be used for ulterior purposes to harm my client, Your Worship. So with your permission, they are in the affidavit, but I will not read them onto the record because we are streaming live.
Any comment? None. We can. Council, Mr. Kasper, I see you look like you are trying to rise up.
Your Worship, I'm easygoing. I haven't said
it's
anything.
it's
Yes.
in order. Yes.
Okay. Your Worship, the applicant's notice of motion is at page 1. The applicant seeks the following orders. The first order is that the applicant...
Yes, the notice of motion is part of the record. Can we then move to the affidavit?
As it pleases
Yes.
Your Worship, the notice of motion is attached. His affidavit is as follows. I, the undersigned Leo Stephanus Nandao, do hereby make oath and state I am a major 36-year-old male with residential address situated at Ondangwa, Republic of Namibia. The facts contained in this affidavit, save where expressly indicated to the contrary, are within my personal knowledge and are true and correct. Where I make submissions of a legal nature, I do so on the advice of my legal practitioner of record, whose advice I verily believe to be correct. Thanks. I am the applicant in this application and accused number 9 in the main criminal matter. Nature of application. This is an application for my release on bail pending the finalization of the trial. I respectfully submit, as I will demonstrate herein, that I am a worthy candidate to be admitted to bail and that the interest of justice permits my release on bail. The purpose of this affidavit is to provide the Honorable Court with my personal circumstances and to provide the grounds of opposition raised by the state and to address the grounds of opposition raised by the state, as well as to address other factors to be considered by the Honorable Court in determining my application to be released on bail. I am advised that I, as the applicant accused person, bear the honors to establish on a balance of probabilities that I am a worthy candidate to be admitted to bail. Personal particulars. I am a major male and Namibian citizen with identity number. I was born on 24 October at Onamulunga village, Oshikoto region in the Republic of Namibia. I have one valid passport with passport number. This passport is currently...
Can you maybe just read the last 2 digits?
All right.
Just to say passport number, the last two
As it
digits,
pleases,
ending with 3.
as it pleases the
Yes.
court. I have one valid passport with passport number P ending with 33. This passport is currently in possession of my legal practitioner and is available for surrendering to the ACC at any time. A copy of my passport is attached hereto and marked as annexure LSN1. I'm a qualified plumber by profession, having obtained the following qualifications from Valombola Vocational Center: General Construction Level 1 Plumbing Certificate, General Construction Level 2 Plumbing Certificate, and General Construction Level 3 Plumbing Certificate. This is evidenced by statements of achievement issued by the Namibia Training Authority, copies of which I have attached hereto as annexures LSN2, LSN3, and LSN4 respectively. I reside in a house owned by my cousin situated at Erf, ending with 4, extension 24 in Ondangwa. Unfortunately, a few days after I was arrested and whilst I am in custody, this house was broken into and many of my personal items were stolen. I have not taken up residency nor citizenship in other foreign countries. I have no relatives living outside of Namibia. I have no assets outside of Namibia. I'm not married. I'm a father of one child, a girl, aged 9 years old. My daughter lives with my cousin and I'm responsible for her daily upkeep as her father. I'm self-employed as a plumber and sometimes undertake small construction jobs to make a living. From those activities, I make approximately 10,000 Namibia dollars per month, which varies depending on whether I'm able to find such jobs. Should I be granted bail, I'll be able to afford bail in the amount of 5,000 Namibia dollars, which is available in cash, sourced from friends and family members. I do not own any immovable property. However, I'm in the process of constructing a residential dwelling for myself at Mulunga village in the Oshikoto region in Namibia. I have no history of antisocial behavior. I also have no pending trials before any criminal court, nor do I have any previous convictions. I submit that all my financial and cultural ties are in Namibia. Arrest and factual background. I was arrested on 10 July 2025 and made my first appearance before the Honorable Court on 11 July 2025. I received a phone call from the ACC investigators requesting me to meet with them at Ondangwa. I agreed and cooperated, went to meet them where I was arrested. Charges. I am charged with the following 2 charges. Count 6, contravening Section 34A and B, read with Section 45(1)B, read with Section 46, Sections 32 and 49 of Anti-Corruption Act 2003, Act 8 of 2003, corruptly giving gratification. On the 17th of December 2022, the accused person corruptly paid a gratification to wit 500,000 Namibia dollars into the bank account of Quality Meat Supply CC. Account number Bank Windhoek 802348961, which money was transferred on even date into the bank account of Panduleni Farming CC, Bank Windhoek, account number 802539531, for the benefit of Jennifer Hamukwaya, who was an employee in brackets Executive Finance and Administration at Namcor, which Jennifer Hamukwaya, in her capacity as Executive Finance and Administration, approved the supply of fuel to the value of 238 million for the benefit of Enercon Petroleum CC, to which company the accused was 100% shareholder. Count 61, fraud, that the accused person is guilty of fraud, whereas the accused did between December 2022 and May 2023 at or near Windhoek in the district of Windhoek, the did wrongfully, unlawfully, falsely, and with intent to defraud, give out and pretend to Namcor that fuel for the value of 280,000 there, which Namcor had supplied to Enercon Petroleum CC.
How much?
Your Worship, we copied the charge sheet exactly as it is written by the state. So there are a couple of errors. We've also indicated that at the end of the page where we put the CIC in brackets. It's duplicated exactly the way the state wrote it. It says 238,000, but thereafter it says 238 million again, which Namcor has supplied to Erongo Petroleum CC, had actually been paid for, and it then and there by means of the said misrepresentation induced Namcor to act to its own actual prejudice by supplying fuel to Erongo Petroleum CC in the amount of 238 million Namibia dollars. As a result of the said misrepresentation, Namcor suffered an actual loss of 238 million Namibia dollars, whereas in truth and in fact the accused, when he so received the fuel and pretended as aforesaid, well knew that his representation was fraudulent, and thus the accused did commit the crime of fraud. Alternative to count 61, theft by false pretenses. Theft by false pretenses, that the accused is guilty of the crime of theft by false pretenses, in that between December 2022 and May 2023, and at or near Windhoek in the district of Windhoek, the said accused did unlawfully and with intent to defraud and to steal, misrepresent to Namcor that the fuel to the value of 238 million Namibia dollars, which Namcor had supplied to Erongo Petroleum CC, had actually been paid for, and did by means of the said obtain from Namcor fuel to the value of 238,000, whereas the said accused, when he so pretended as aforesaid, well knew that the Erongo Petroleum CC and or its representatives were not entitled to receive the fuel provided, and thus the accused did commit the crime of theft by false pretenses. So those are the charges as proffered by the state. I deny the aforesaid allegations against me in the strongest terms and intend to plead not guilty to those two charges if the matter proceeds to trial. During the court proceedings of 14 July 2025, the state raised the following grounds in opposition to my application for bail: risk of abscondment, high risk and the accused will interfere in ongoing investigations, seriousness of the state's case, and additional suspects still must be arrested. Thus, if released on bail, there is a risk of interference. Backgrounds and merits. As stated earlier herein, I deny the allegations against me in the strongest terms. I'm advised that I do not have to, at this stage of the proceedings, deal with the merits of the charges against me. However, I deem it appropriate and important to deal with the merits already in this application for bail, particularly in light of the state's contention that I corruptly made payments for the benefit of Jennifer Hamukwaya and that I defrauded Namcor. Nothing can be further from the truth, and I submit that it is impossible for the state to present objective facts to substantiate its allegations against me, as there is no substance in those allegations. There is simply no factual basis on which the allegations against me could be premised. Sometime towards the end of the year 2019 or at the beginning of the year 2020, Mr. Austin Elindi, Austin hereinafter, approached me with an idea of registering a petroleum company, resultantly a close corporation named Petroleum Erongo CC, Erongo Petroleum hereinafter, with its principal business being the supply of all petroleum products, import and export and transportation, was registered. During these proceedings of the current bail applications by the other accused persons in this matter, my legal practitioner of record was furnished with several documents, including founding and amended founding statements, bank statements, and fuel supply agreement of Erongo Petroleum from the docket by the state councils. A copy of the founding statement and amended founding statements are attached hereto and marked Annexure LSN 5. A cursory reading of those registration documents revealed the owners of Erongo Petroleum to be as set out hereinafter. At registration of Erongo Petroleum on 13 February 2020, the membership interests were as follows. Ms. Seima Immanuel held 40%, Ms. Mateus Pendukeni Iambo held 20%, and Ms. Leonardo Stephanes held 40%. On 23 November 2020, the amended founding statement of Irongo Petroleum indicates that membership interests were held as follows. Me, Leon Andaro Stefanes, held 70%, Mateus Pendukeni Iyambo held 15%, and Christina Kambodi Ndafenongo held 15%. On May 2022, a further amended founding statement of Irongo Petroleum indicates that I held 100% members' interest. Another amended founding statement of Irongo Petroleum indicates that I held 100% members' interest with an effective date of change of 27 October 2023. A further amended founding statement of Irongo Petroleum indicates that Austin held 75% interest, whilst I held 30% members' interest, with an effective date of change of 13 November 2023. A further amended founding statement of Irongo Petroleum indicates that Austin held 100% members' interest, with an effective date of 15 February 2024. I recall that during February 2024, I transferred my 50% membership interest in Irongo Petroleum to Austin, thus making him currently the holder of 100% members' interest in Irongo Petroleum. According to those documents provided by the state, Seima Immanuel ceased to be a member of Irongo Petroleum on 23 November 2020, whilst Mateus Pendukeni Iyambo and Christina Kambodi Ndafenongo ceased to be members only on 27 October 2023. Thus, during the period from December 2022 until May 2023, the members and authorized signatories of the bank account of Irongo Petroleum were me, Mateus Pendukeni Iyambo, and Christina Kambodi Ndafenongo. Thus, the state's allegation that I was during the said period the 100% shareholder of Irongo Petroleum is factually incorrect and at odds with the documents in the police docket. I pause here to state that although during the period from December 2022 until May 2023, the aforesaid persons were also members and authorized signatories of Irongo Petroleum bank account, only I was arrested and charged. During my tenure as member of Irongo Petroleum, I played no role in the operations of the business, apart from signing documents that required the signatures of the members. The operations of the business were attended to by Austin. To enable Austin to fully attend to the lawful business operations of Irongo Petroleum, the members would sign special powers of attorney. The special powers of attorney authorized Austin to deal with all lawful aspects of the business of Irongo Petroleum without further input from the members. With the special power of attorney, Austin was nominated, constituted, and appointed as the lawful agent of Irongo Petroleum. This power of attorney granted Austin broad authority to act on behalf of Irongo Petroleum in any matter relating to signing of all documents relating to the following: overdraft facilities, hire purchase agreements, term loan agreements, commercial loan agreements, commercial bond agreements, industrial bond agreements, mortgage loan agreements, stop payments, in bold electronic fund transfers, debit order authorization, stop order authorization, request for deferment or extension of payment, performance guarantees, demand guarantees, letters of intent, letters of undertaking, cessions, and pledges, suretyships, both limited and unlimited, and in bold again, application for debit cards, and all documentation relating to foreign exchange transactions. Generally, the special power of attorney was granted for the purposes stated above, to do or to cause to be done whatever shall be requisite as fully and effectually for all intents and purposes, as if Irongo Petroleum itself were personally present and acting, because the special powers of attorneys explicitly stated that the attorneys and or the agents shall lawfully do or cause to be done by virtue of this presence. I have attached here to a copy of one such special power of attorney, which was signed at Windhoek on the 27th day of June 2022 by me, Seima Immanuel, and Matthews Pendukeni Iyambo, in the presence of two witnesses. It is marked as Annexure LSN 6. Even though as one of the authorized signatories on the bank account of Erongo Petroleum, I had no access to such bank account, and as such, access and power was assigned to Austin, nor did I have online banking access. Therefore, I could not have made the payment of 500,000 Namibia dollars on 17 December 2022 to Quality Meat Supply CC, as alleged by the state in count 60. I do not know who made the transfer, nor under which circumstances, nor for which purpose or what purpose that transfer was made. It is evident from the bank statement that the transfer, which is the subject matter of count 60, appears to be an electronic fund transfer. I did not have access to any online banking access details nor bank account details of Erongo Petroleum, and therefore could not have made the payment or electronic fund transfer. To transact on a bank account, a person, in addition to being an authorized signatory, requires online banking access and login details. It is incorrect for the ACC and the state to assume that the transfer was made by me simply on the basis of me being a member of Erongo Petroleum and an authorized signatory to its bank account, and to arrest and charge me on such a basis. I deny that I, in my personal capacity, nor on behalf of Erongo Petroleum, made the transfer of 500,000 Namibia dollars to Quality Meat Supply CC. Therefore, based on the above objective facts and the attached special power of attorney, the state does not have a prima facie case against me, let alone a strong case. Had the ACC investigators conducted an objective and fair investigation, they would have found this out with a simple phone call or a visit to a local bank, Windhoek branch, where the bank account is held. Count 61, fraud and its alternative, theft under false pretenses, is even more worrisome, as not only is it couched in the loose terms, leaving out the material allegations such as to whom exactly the alleged misrepresentation was made to, as well as the quantity of fuel supplied, the charge is also without any factual basis. Based only on those bank statements of Erongo Petroleum provided by the state, the total amount paid to Namcor by Erongo Petroleum for fuel is 93,656,339 Namibia dollars and 88 cents. Here is a breakdown of individual payments that sum up this total. For October 2022, for those dates in October, it's 4.3 million, 3 million, 5 million, 2 million, 3 million, 1 million, 2 million. For November 2022, for those dates in November 2022, it's 5 million, 384.47 million, 3 million, 2 million, 3 million, 500,000 Namibia dollars, 3 million, 1.6 million, and 2.5 million. For December 22, and those dates depicted there for December 22, the payments are 5 million, 1 million, 500,000, and 1 million Namibia dollars. For January 2023, on those dates, the payments are 10 million, 1 million, 1.5 million, 500,000, 1 million. For February 2023, and on those dates, it's 1 million, 1.5 million, 3 million, 2 million, 1.2 million, 400,000, 900,000, 300,000, 500,000, 2 million, 500,000, and 1 million. For March 2023, and those dates in 2023, it's 800,000, 1 million, 1.2 million, 4.5 million, 800,000, 305 million, 10 million, 3 million, 3.5 million, and 1 million. As well as for April 2023, and those dates of April 2023, the payments are 1 million, 800,000, 5 million, 1 million, 5 million, 3 million, 1 million, 1 million, 500,000, 1 million, 1 million, and 1 million. And lastly, for the month of May 2023, up to the 22nd day of May 2023, as per the statement, the payments are 1 million, 3 million, 700,000, 1 million, and 1 million Namibia dollars. Based only on the bank statements for Erongo Petroleum CC, provided by the state, the total amount paid to Namcor for fuel from 1 December 2022 to 30 May 2023 is 59,500,000 Namibia dollars. A copy of those bank statements is attached here too as Annexure LSN 7. Therefore, it is evident that the state also on this charge of fraud, as couched in count 61 and its alternative charge, does not have a strong case against me, not even to mention against accused 15, Erongo Petroleum CC. More importantly, the supply and purchase of fuel was done in accordance with the fuel supply agreement between Erongo Petroleum and Namcor Trading and Distribution Pty Limited. As mentioned earlier, a copy of this agreement was also provided to me by the state councils through my legal practitioner, a copy of which I attached here to, marked as Annexure LSN 8. In that agreement, the parties have expressly agreed to quantity of fuel to be supplied, the payment terms, including the cancellation of credit facilities in the event of non-payment, as well as a debt collection process and arbitration process in the event of any disputes arising between the parties. This furthermore makes it plain that the state does not have a strong case against me in respect of the fraud charge in charge 61 and the alternative of theft under false pretenses. Further considerations. As stated already, I am a holder of a validly issued passport which I am prepared to surrender if ordered to do so by the Honorable Court. In addition, I undertake to limit all traveling to within the jurisdiction of Namibia and to adhere to any further bail conditions in respect of traveling. Furthermore, I wish to reiterate that as soon as I became aware that the authorities were looking for me, I reported myself to the authorities and was arrested. Therefore, I have demonstrated that I did not attempt to evade arrest, nor is there a risk of me absconding the trial. I have at no point interfered in the investigations. If one has regard to the charges as well as the documents disclosed by the state, the bulk of the state's case will be premised on documentary evidence, in brackets, bank account statements and commercial agreements, etc., over which I have no access nor control. Therefore, I cannot and will not interfere in the state's investigations. Furthermore, I do not know the identity of the state witnesses. However, if the identity of the witnesses is made known to me, I will not make any contact with such witnesses. The state on this ground of interference also indicated that there are more suspects to be arrested. I do not know the identity, nor do I intend to interfere with the arrest of any of such suspects. Therefore, I cannot interfere with the investigations in this regard. The last ground on which the state objects to my release on bail is that it has a strong case against me. I humbly submit that I have demonstrated herein that the state's case against me is very weak. Even on the investigations conducted thus far, the state's case is very weak given the standard of proof required to secure criminal convictions in Namibia. I am advised that I, as the applicant, must make out a case for my release on bail, addressing the relevant considerations that the above Honorable Court will have regard to when exercising its discretion as to what the interests of the public or the administration of justice will require, as set out in the CPA. Even though I am not required to do so, I further submit as follows. I will not endanger the safety of the public or any person or commit any offense if released on bail. There is also no evidence of any likelihood that I pose a danger to the public or any individual's safety. I will not attempt to evade any court proceedings that may take place up to the conclusion of the main trial. I intend to have my day in court and to prove my innocence in trial. I have no intentions of becoming a fugitive of the Namibian criminal justice system. I will not attempt to influence or intimidate any person or conceal or destroy any evidence. I am, to the best of my knowledge, unaware of the identity of the witnesses that may be called in the trial. Should I become aware or be informed of their identity, I undertake not to interfere with them. The court may also impose any conditions that cause me to refrain from any conduct with such person, and I intend to abide by these conditions. I will not do anything that will undermine or jeopardize the objectives of the proper functioning of the Namibian criminal justice system, including its bail system. I will not do anything that will in any way disturb the public order or undermine the public peace and security, nor will my release on bail cause such effects. Lastly, I undertake to abide by and adhere to the bail conditions which the Honorable Court may impose for my release on bail. In the circumstances, I submit that I have made out a case that I am a worthy candidate to be admitted to bail, and that my release on bail, pending the finalization of the trial, is indeed in the interest of justice. I therefore pray for an order granting my release on bail as set out in the accompanying notice of motion. That is the end of the affidavit of accused number 9 in support of his application for bail.
Yes, Mrs. Gebhardt, for purposes of these proceedings, can we then mark the affidavit for your client, that is the seventh
Yes.
applicant, as Exhibit G?
As it pleases the court, I'm indebted to the court.
Yes, then it's opportune time for the court to adjourn for lunch break. For the record, Exhibit G is the affidavit in support of the seventh applicant, that is Leo Stephanas Nandango's bail application.
Worship, I just wanted to mention something. I think that will then leave us to the viva voce evidence, seeing that the affidavits are now before court. I've just received, as we were busy, notification from the investigating officer that he was with some other duties. He can be here at 2:30, 14:30. So I just want to alert council so that it's not being said we are late. At least if we come at 14:30, that is the reason. And I don't know if there is any problem with that.
No, we have no problem, but all what we urge in the interest of time, your worship, that if it is 2:30, we must start at 2:30.
I know, and I'm sure Mr. Casper is listening. He put it on record that he's an African man. So, but yes,
As the
14:30 is the time. The court adjourns.